Hello, everyone. I am Jason Tang, a patent attorney with Potter Clarkson, a European IP law firm. We are pleased to be supporting the Graphene Hackathon team again, and I thank them for inviting me to speak about IP and join the Q&A session after this talk. IP is a very broad subject, and today I will be focusing on how startups can develop an IP blueprint for growth in order to attract and secure funding. A recent report from the Scale Up Institute, Innovate Finance, and Deloitte identified a £14 billion funding gap for fast growth SMEs. What does this mean for innovative startups who are looking to obtain investment in order to scale up? In the face of the economic fallout from the pandemic, innovation is vital. Being able to turn good ideas into a commercial success at scale can have a transformational impact on the wider economy. However, even the most groundbreaking of inventions requires investment to become a viable market proposition. The road to securing funding is not always clear, with various hurdles to overcome before winning the trust and backing of investors. Securing funding is fiercely competitive territory as investors apply a forensic approach to identifying the risk and opportunities with each investment target. Intellectual property alone will not likely secure funding, but a weak IP position could significantly impact on valuation by as much as 70% in our experience, or see an investor walk away altogether. Investors are looking for the most lucrative returns, and if ever, further evidence were required to show how IP rights can underpin investment and support a strong return. A new Europe-wide study by the European Patent Office and the EU Intellectual Property Office shows that SMEs with intellectual property rights generate 68% higher revenues per employee than those who don't. I will go through the 5 key ingredients that will put a startup in the strongest IP position to attract and secure funding. Firstly, establishing clear ownership. Failure to establish proper ownership of IP is the #1 deal breaker. Any gray areas surrounding who owns IP will signal alarm bells for a potential investor. Innovation, especially in startups, can occur before commercial relationships and business processes have been formally defined, which can make determining IP ownership less clear-cut. Where appropriate, the necessary assignments should be signed and registered. There should be clear and written agreements in place for any joint ventures or collaboration agreements. Establishing a process to be followed for determining ownership during collaborations is also important and can avoid difficult conversations after the event. In more established SMEs, commercial partnerships may have evolved over time, but without formal agreements in place, this is something that should be remedied immediately. Next, effective innovation capture. Understanding what IP your business may have and what you might be able to protect is not always obvious. It is always worth seeking professional advice early on to determine which IP rights you might be able to secure. Robust procedures play a big part in creating the right culture for effective innovation capture. The first step will be to carry out an audit to evaluate your IP assets. What is your IP? Have you come up with a new graphene application or a new manufacturing process? Does the innovation lie in a technical improvement such as better performance or higher efficiency? However, more often than it should be, many innovations end up not being protected because they are mistakenly considered as not innovative enough. A proper assessment of innovativeness must be carried out from both technical and legal perspectives. After identifying your IP, you then need to check your IPR. Do you have registered IP rights to protect your inventions, brands, and designs? Who owns the IP and the IP rights? Are there suitable IP agreements in place? The second step is to analyze your IP situation. How strong is your IP portfolio? By this, you need to ask yourself whether your IP rights adequately cover your commercial products or services. Are you using the correct type of IP right? Is the IP right sufficient to prevent third parties from easily designing around your protection? When will your IP right expire? Also, do your due diligence in checking whether your proposed activity could infringe a third party's rights. Next, take action to improve your IP situation to mitigate risk and take advantage of opportunities. If still possible, secure IP rights by filing applications. Understand your competitor's IP situation to assess potential IP threats and opportunities by performing freedom to operate searches to identify third-party IP rights that belong in a specific field or to a certain competitor, and also to identify white spaces that are ripe for technology R&D and commercial exploitation. Your IP situation can also be improved by implementing internal procedures such as internal IP awareness training and creating an IP register and keeping it up to date regularly so that opportunities are not overlooked. What should be included in an IP register? In short, everything. Not just patents, trademarks, and registered designs, but all forms of IP such as copyright, trade secrets, and know-how. Trade secrets is often overlooked, and in some sectors, it is often the most important form of IP. They need to be identified and managed carefully. Basic information such as application numbers and current status is essential. It is always the first piece of information that is asked for in due diligence and will set the tone for your approach to IP. For a comprehensive approach, also upload and save all published applications and granted patents, pending and registered trademarks and designs to your data room. This takes minutes if you do it as you go along. It is like keeping your house tidy so that you are always ready for visitors, or in this case, investors. Ensure you include an overview document so that investors can see at a glance what IP you have and how it fits in with the business plan. Once you have identified and captured your IP, is that the end of it? The answer is no, because the commercial environment is fluid and many things can change overnight. As a result, your IP innovation capture process needs to be reviewed and refined regularly in order to adapt to new commercial environments. Next, having a sound strategy. IP is not a tick box static exercise. An IP strategy should support your business goals and can adapt as your commercial objectives evolve over time. From the outset, build an IP strategy around your business plan and make sure it's written down. An investor will expect you to have the answers to the following questions. What do you need to protect? When and where? How will those rights help you to achieve commercial goals? How will you drive future innovation and where will you focus? What type of partnerships will be most beneficial? Put yourself in an investor's shoes. They are focused on whether you can provide them with a return on their investment. They are looking for clarity in your approach A strategically sound business plan where it is easy to see how the IP rights will help to achieve the commercial objectives. These objectives will evolve, and the IP strategy requires regular review to remain fit for purpose. Now we come on to the fourth point, which is about market awareness. A growing business can be all-consuming, but a sound IP approach takes into consideration the wider marketplace in which your business is operating and any potential third-party rights. You need to demonstrate awareness of the need to consider freedom to operate, the freedom to test, market, or sell your goods and services, and the availability of proposed trademarks or brand names, and show potential investors that you understand the distinction between obtaining your own IP rights and the impact of third-party rights on your commercial plans. Investors will ask you what freedom to operate and trademark availability searching you have done. And the most important thing is to demonstrate that you have given this due consideration and have a sound strategy in place. Your approach will be dependent on multiple factors, including your market sector, your territories of interest, attitude to risk, how close to market you are. Extensive searches and legal opinions are usually not appropriate for early-stage companies. Instead, consider what you can do to mitigate future risk. For example, maintaining a watch for the publication of competitors' patents, as well as undertaking the necessary clearance searches for any proposed brands and trademarks. Last but not least, good timing is important. Knowing when to act is critical to a sound IP approach. Disclosing information relating to an invention before a patent application is filed is an all too common mistake. This can happen with many startups that are too eager to share ideas to seek partners and investors. Patent applications must be filed before the invention is disclosed to third parties unless effective confidentiality agreements are in place. In the EU and UK, the assessment of novelty is absolute, which means it must not have been previously disclosed. Therefore, it is preferable and safer to have filed applications before disclosing information about your innovation to any third party, including a potential investor. But you can also file too early, and doing so too far in advance without the supporting data could weaken your position further down the line. While it is desirable to file as early as possible to avoid other parties filing first, you run the risk of your patent application being deemed invalid if you have insufficient data such as process parameters or experimental data. Therefore, have a mechanism in place to regularly assess the IP and decide on the right timing to file. IP laws can differ from country to country, and therefore understanding where your competitors and markets are located can influence the timings in your filing strategy. Your end goal with IP due diligence is to instill confidence and build trust with a potential investor. Investors look for security when seeking to invest in companies. While investors are prepared to take on varying degrees of risk, you need to show an IP approach that doesn't signal alarm bells. Ensuring you are clear on these 5 areas will reduce the chances of IP being the reason an investor walks away. I have now come to the end of my talk, which hopefully has given you some food for thought. I will be joining the Q&A session in a while. Please feel free to get in touch during or after the event if you have any questions about IP. My contact details are on this slide.